Spartan Steel and Alloys and Martin and Co. 1973. If you have been studying pure economic loss in English tort law, you have come across this case. But are you sure of the facts of the case? And are you sure as to what was decided in court? In this video, I will explain just that. We'll look at the facts of the case, we'll look at what both parties posed to the courts, and I'll explain what was decided at first instance and in the Court of Appeal. Hi, I'm Denise, and you're watching Law with Denise. So before we look at the facts of this significant case, let us explore or identify who was involved in the case. So of course we had Spartan Steel and Alloys, and we had Martin and Co. Spartan Steel and Alloys were a steel producing factory in Birmingham, England, and Martin and Co. were contractors. We also have another party, a third party, and that is Midlands Electricity Board. And Midlands Electricity Board had contracted Martin and Co. Now let's get into the facts of the case. So Martin and Co. were contractors. They were doing some work, digging up roads on a road close to Spartan Steel and Alloys steel factory. Now, when they were doing this work, they did so negligently, unfortunately, and as a result of their negligence, they hit a cable, and Midlands Electricity Board had to shut down electricity in the area. So this meant that Spartan Steel and Alloys, the steel factory that was close to where Martin and Co. were doing the digging, did not have any power supply for 14.5 hours. So what exactly happened during those 14.5 hours? Well, during that period, Spartan Steel and Alloys said that they could not maintain the temperature necessary to maintain their furnaces in order to produce the products that they normally produce because there was no electricity. And as a result of them not being able to maintain this particular temperature that they needed to maintain, they had to firstly make some changes to a particular job that was being done at the time the power supply cut off. They said they actually had some ingots being made in a furnace, and they were concerned that if they just left them in the furnace, this would cause damage to the furnace. So they tried to find another way to finish the job, another method. And unfortunately, as a result of this effort to find another method to complete the job, they caused damage, or damage was caused to the product of damage of about 368 pounds. Additionally, according to Spartan Steel and Alloys, this damaged product was of less value than it would have been had they not run into the problems that they run into when they tried to find another method to create it. And this loss, they said, was equated to 400 pounds. Additionally, Spartan Steel and Alloys said, during that 14.5 hours, we could have, or we would have, put in 4 more melts into furnaces, but we could not do this because the electricity supply had been cut off. And because we could not do this, we lost an extra 1,767 pounds. So those are the facts. So what exactly were Spartan and Steel and Alloys claiming for? There were 3 claims. The first was for the 368 pounds that they claimed they lost because of the damage that was done to the melts that were actually in the furnaces at the time of the power cut. Secondly, they said they were claiming for 400 pounds. This, they said, was what they would have earned on these melts had they not been destroyed or damaged in the furnaces. Thirdly, they claimed for 1,767 pounds, and this was for the money they would have made from the 4 melts they would have put into furnace had the power supply not been cut off during those 14.5 hours. So 3 claims were put forward. What did Martin and Co. say? What did the defendants argue in response? Well, Martin and Co. did not deny their negligence. And they actually accepted claims 1 and 2. So the claim for £368 and the claim for £400. But where they disagreed with Spartan Steel and Alloys was with regard to the third claim, and that was for the £1,767. And this, they claimed, was not recoverable because it was a claim for pure economic loss. Now, if you're not sure what is meant by pure economic loss, I do have a video in which I explain that. So you can follow the link to that video in the description. So the defendant said, we're not accepting the third claim because that is a claim for pure economic loss, because that claim is not connected or is not a consequence of any injury to property nor any injury to person. The first claim for £368, that is a claim for injury to property, they said. The second claim for £400, they said, that is a consequence of injury to property, because remember that £400 in the second claim was a claim that Spartan Steel and Alloys put forward because they said they would have made money on those melts if they had not been injured. The injury to the melts, right, physical injury to melts, consequence of that, not making £400. Martin and Co. said was okay because this is consequential loss, which is permitted in English tort law. But the third claim, they said, oh no, that is not recoverable because that is not a consequence of any injury to property or person. So now we know what the facts are, we know what the claimants argued, and we know what the defendants argued. But what was decided at first instance? Well, at first instance, Spartan Steel and Alloys were successful with every claim. So all three claims were successful. But Martin and Co. did not like this decision, so they appealed, and they appealed to the Court of Appeal. So what happened in the Court of Appeal? Spartan Steel and Alloys were successful with claims 1 and 2, but claims 3, the Court of Appeal said they would not be able to recover for because that was a claim for pure economic loss. And according to the Court of Appeal, under English tort law, the general rule is that recovery is not possible for claims for pure economic loss. So there you have it, the facts of Spartan Steel and Alloys and Martin and Co. 1973, the decisions reached at first instance and in the Court of Appeal. Until next time, take care, and remember, like, share, and subscribe. Bye-bye.